Good morning. This is another edition of the Board Watch. And again, this is a new program, and we will be working out the kinks and the details as time progresses. This morning, we will not be joined by my friend and colleague Hassan Barnes, Attorney Barnes. This morning is engaged in a matter in the Baltimore City Circuit Court. So, last week, I went rather hurriedly through the explanation of the Board of Estimates, what it is and what it does. And I want to go back today and slow down just a little bit and try to more clearly explain exactly what the Board of Estimates is and what its authority is. The Board of Estimates of Baltimore City is responsible for awarding contracts and supervising all purchasing by the city. There are contracts that require competitive bidding, which means that the city advertises in local newspapers and on the email and marketplace and so forth for companies or organizations to make offers to the city to provide goods and services that the city elects to purchase through a competitive bid process. And under the city charter, the contract is to be awarded to the company that offers the lowest responsible and responsive bid. Those terms, responsible and responsive, have a great meaning to procurement lawyers such as I, and ultimately have great meaning and significance to the citizens of Baltimore because the application and interpretation of those terms will, in many cases, in fact, in most cases, hopefully, lead to the decision as to what company will actually be awarded the contract and how much the taxpayers will pay for that work. Now, let me not be misleading. The fact that the company or the bidder offers the lowest price and that a contract is entered into for that price does not mean that that will be the final price paid by the city for those goods or services. In many cases, the final price over the course of the contract is adjusted for various reasons. It can be adjusted because of a change in the quantity of work that's to be performed. It can be adjusted because during the course of the work, the contractor or vendor encounters unforeseen and unforeseeable circumstances that affect its manner of delivery or the price that it will have to pay to get the work completed. And so the contractor requests a thing called a change order. A change order is simply what it says. It's a request for a modification of the contract so that an adjustment can be made for either the price or the length of time allowed for the work to be performed and so forth. But I don't want to, my goal is not to have the viewers, this is not a course in procurement law, but in order to understand what goes on at the Board of Estimates and to understand the basis upon which the board, by law, makes decisions on the award of contracts, you have to have a certain amount of understanding of the procurement process itself. And in Baltimore City, that process is dictated by the terms of the Baltimore City Charter. Now, the next meeting, the Board of Estimates, as you know from last week, or perhaps you don't recall, I'll tell you how the board is comprised. The Board of Estimates consists of 5 people. It's the mayor, the city solicitor, who's appointed by the mayor, the Director of Public Works, who's also appointed by the mayor, the City Comptroller, who's a citywide elected official, and the President of the City Council, who's also a citywide elected official. You know that we've recently had a change in the Board of Estimates. Zeke Cohen was elected to replace Nick Mosby as the president of the Baltimore City Council, and Mr. Cohen, Councilman Cohen, now presides over meetings of the Baltimore City Board of Estimates. The Bill Henry, as you know, is the Baltimore City Comptroller. Khalil Zaid is the director of the Baltimore City Board of Department of Public Works, and Ebony Thompson is the Baltimore City Solicitor. City Solicitor means the city's top lawyer. The city solicitor, the law department of Baltimore City provides advice and consultation to the mayor and to the departments and other city officials. But the city solicitor is the lawyer for the mayor and city council as a whole. Many people think that the city solicitor's only duty is to fulfill the desires and wishes of the mayor. Even though appointed by the mayor, in fact, the city solicitor is the chief lawyer for the entity, the municipality known as the mayor and city council, which consists not just of the mayor, but also of the legislative branch, the city council itself. So now, the Director of Public Works, as you know, has responsibility for much of the public improvements, the public works that are taking place in the city, with the exception of streets. That's a separate department. Streets, sidewalks, typically not really sidewalks. They can go either way, but street construction or reconstruction generally is under the jurisdiction of the Baltimore City Department of Transportation, to which there's been a recent change in that leadership. Now, the next meeting of the Baltimore City Board of Estimates is on next Wednesday, January 22nd. And I've had an occasion to review the agenda for that meeting that is actually published by the city comptroller. And now let me give Mr. Henry kudos, because in organizing the agenda, the comptroller's office has done a much better job of making it understandable for the public. Now, the Board of Estimates used to meet weekly. It now meets bi-weekly. The result is the agenda has gone from maybe 50 or 60 pages to now, in most cases, well over 100 pages. It's not likely that anyone, including myself, who has access will have the time or interest to go through each of the pages of the agenda to find items that may be of concern. The comptroller's office has made that task, that daunting task, a little easier by creating a summary, an executive summary, if you will, of those items that are on the agenda that are of most interest, particularly the items relating to the award of contracts for the performance of public works. Public works contracts can range anywhere from $100,000 to several $100 million. And so those type of transactions are noted and listed in the summary that the comptroller's office prepares and puts at the front of the agenda to give the public some guidance. In addition to that, the meetings of the Board of Estimates for Baltimore City residents can be viewed on city cable channel. I think it's channel 25. If you want to see it, if you want to see the board in operation. During the COVID period, that was the only opportunity to participate on the public, because during that time, the board met only virtually because of COVID. There's also, I think, a call-in number that you can use for if you want to participate or listen in on a live basis. And then I think, of course, the board meetings are eventually publicized or broadcast over YouTube. I don't know how current the YouTube channel is in terms of the meetings, but I believe that that is another source. And I urge you, that is, listeners and members of the public, to tune in from time to time to the Channel 25 or call in, or at least to access the agenda, which is available online by going to the website of the city comptroller and following the menu directions to at least review the agenda so that you can apprise yourself to some extent of what's upcoming, and so that you know as much as you can in advance what matters the board is likely to or is scheduled to consider. Of note for the upcoming meeting is really the special meeting of the board on January 22nd, next Wednesday, scheduled for 5 p.m. That is the meeting where the board is going to be discussing rate increases that the citizens are going to have to pay for water and sewer services from the city. As you know, you may not know, the city has been operating under a consent order between it involving the Maryland Department of Environment and the Federal Environmental Protection Agency. The consent order that I think was originally entered into in 2005, under which the city is required to upgrade its water and sewer system, particularly the sewer, the matter of handling of sewage. You originally, and when I say originally, I'm talking about hundreds of years ago, certainly even before I was born, I was reminded, the sewage system in the city was constructed to operate on a gravitational basis, meaning that the conduit, the lines, the sewer lines were deliberately designed so that there was flow down towards the inner harbor, ultimately into the harbor, and then on out into the Chesapeake Bay or its tributaries. That was okay, I suppose, when we were talking about a city of a couple of 100,000 people, or maybe 100,000 or 50,000 people, whatever it was in the beginning, maybe less than that, I don't really know. But as the city grew, certainly reaching at one point a population of in excess of 1 million, now down to, I guess, 600,000 or 700,000. Nevertheless, that the quantity, the overflow, was too much to be tolerated by the ecosystem, by the environmental system, and so much so that every time it rains, any hard rain will result in a sewage overflow. And so the government, the federal government, the state government stepped in and to provide financial and other assistance to the city to remedy that problem. And the city, since 2005, I believe, has undertaken the process of upgrading its facilities for handling sewage at the Back River Wastewater Treatment Plant and at the Patapsco Wastewater Treatment Plant. And that work is ongoing. There have been delays. You've seen about the delays. There was an explosion down at Back River at one point in time. It is tedious. It is tedious work. It is expensive work. It is time-consuming work. And the reason why it seems to be all occurring at once is because, politicians deal with what the voters can see. You don't see these underground utilities. And so, quite frankly, over many, many, many years, there was tremendous neglect. There was little, if any, maintenance of the system. The system was allowed to deteriorate to the point where almost on a daily basis. There was some rupture somewhere in a water line or sewer line and so forth. And so there's several contracts that are outstanding now for so-called emergency services, emergency repair services. And I think that if you stop for a moment and think about what you've witnessed yourself in your neighborhoods, you probably encountered an emergency break of some sort that has occurred over time, and you see contractors working to try to enact, in most cases, temporary repairs in advance of the permanent upgrade that is underway for the entire system. One issue that I will focus on just for a moment involving underground utilities and conduits has to do with something that was of great interest at the time, and perhaps this full impact is not yet known, but that has to do with what some describe as the debacle back in January or so of 2023, involving the city's transfer of at least control, if not ownership, of 700 miles of city conduit system over to BGE. So that historically, at least I'm told, again, I wasn't around, but the conduit system was originally built by the utility company and maintained to the point where the cost of maintenance was too high. They gratuitously and graciously turned over the ownership over to the city in exchange for its continued use of which they would pay the city a rent. BG&E utilizes about 70%, I think, of the capacity of the 700-mile city conduit system. And the amount that BGE paid for many, many years for its use was about 16 cents per linear foot. That amount has been increased over the years, and until January of 23, when the whole structure of the relationship between the city and BGE was changed. Now, I bring that up because of the controversy that surrounded that transaction. If you recall, on the ballot during that time, there was a measure which ostensibly was intended to prevent the city or prohibit the city from transferring ownership of the conduit system to a private party. That prohibition was sponsored by subsequent Mayor Bernard Young when he was in the council, and initially, and it was followed by then Council President and now Mayor Brandon Scott. And the idea was that the conduit system, the 700-mile conduit system, was such a valuable asset to the city and to the citizens that the city ought to retain ownership over that facility, the same as the city retains ownership over the public parking garages. Well, something changed. And so in January or so, I think it was, in 2023, following a lawsuit brought by BGE or its parent company, Exelon, against the city, there was a deal negotiated. The lawsuit followed the city's effort to increase the rent that BGE would pay for use of the city's conduit system. As it turned out, I think at the time, the 75 cents per linear foot that BGE was paying was really insufficient to cover not the maintenance costs and the cost of the improvements that were necessary for the system. And so the city proposed to raise that rental fee again. BGE and Exelon believed that action violated the terms of the prior agreement, whereby the rate was increased to 75 cents. They filed a lawsuit. The lawsuit ultimately was settled, I think, at a time that it appeared that the city might be on the losing end, and so that fee increase that precipitated the lawsuit never, in fact, took place. But what did happen, what that action did spawn, was this transaction whereby the conduit system, effective control over it, if not ownership, was transferred to BG&E. Now, what role did the Board of Estimates play in that? That was a transaction that, under the city charter, had to be submitted to and approved by the Board of Estimates. Now, again, the Board of Estimates is 5 people: the mayor, his 2 appointees, and the other 2 elected officials. I believe, and others believe, that the board is only a board when all 5 are present, or at least represented by their duly designated representatives, if not personally present. In other words, the board is only a board when 5 people are there. As you may recall, there was great controversy at the time because City Comptroller Bill Henry and then Council President Nick Mosby, the only 2 independent members of the board, apart from the mayor, opposed the transaction that, as it was then being offered, then being presented under this agreement, the draft agreement with BG&E. And to try to make sure that their opposition was effective, those 2 members of the board pulled a no-show at the board meeting that was scheduled for the purpose of considering approval of the agreement that had been negotiated between the city law department and the attorneys at BG&E. However, the mayor, presumably based upon an opinion of the then city solicitor, Jim Shea, who was chairman emeritus of this law firm called Venable, concluded that, or it could have been Shea's successor, who also came from Venable, the current city solicitor, Ebony Thompson. Nevertheless, the mayor concluded, or was advised, I believe, and acted upon that advice. He concluded that the board could take legal action if only 3 of its members were present. Those 3 being the mayor and his 2 appointees. And so the board, with only 3 members present, or 3 people then purportedly constituting the board, approved the agreement with BGE with respect to the conduit, under which BG&E no longer paid the city rent, but instead made a commitment to use roughly the same amount of money that would have been paid in rent to make certain capital improvements to the system, but only capital improvements that BG&E wanted to make. What the city has the right to suggest certain things, but BG&E has the final decision as to whether or not it's actually going to undertake that work. In addition to that, unless something was changed, and it may have been, but at the agreement as initially approved by the mayor did not provide for a mandatory minority contractor or minority business participation, which was at odds with every other contract involving public works then and now, all of which for that amount of money, for the economic value, all required some commitment to utilize minority businesses. BGE was given the discretion to decide, given the sole discretion to decide how much, if any, minority participation they would use in performing the work required, that it was required to do, and and which kinds of services they would in fact acquire or purchase from minority firms. Those agreements, those terms were considerably more favorable to BGE than 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 uh, uh, than many people believe they should have been. Uh, but there's been, as far as I know, despite their strong opposition, the comptroller did not undertake any legal action with respect to that, and of course, neither did the then president of City Council, Nick Mosby, and as I mentioned earlier, as you well know, uh, Mosby was defeated by the current council president, Zeke Cohen. Now, the board can award contracts on a number of different bases. For the most part, at least for public works, the board is supposed to award the contracts to the lowest responsive and responsible bidder. That doesn't always happen. Last week, we talked about situations where the apparent low bidder was denied award because of a perceived deficiency in the achievement of the minority or women's business participation goals that had been set for that particular contract. And the MBE program, as it exists in Baltimore, was hard fought for. The original ordinance was enacted during the time of when Jackie McLean, if anyone is old enough to remember Jackie McLean, when she was president of City Council and the mayor was William Donald Schaefer. The minority participation was hard fought for, and in the beginning and continuing, I think even to the present, there was tremendous resistance to the implementation of the program, and that resistance took many forms. In many cases, it took the form of putting forth what I call sham minority businesses. That is, minority companies that on paper look like and were supposed to be owned and controlled by African Americans or women or whatever the case may be, but in fact were effectively, for all intents and purposes, controlled by individuals who were not eligible to be considered as either minority or socially or economically disadvantaged. Sham companies, in other words. And so in response to that continuing effort on the part of the established business community to find ways to get around compliance with the MBE program, those charged with the responsibility of enforcing the law adopted what I call a zero tolerance policy, which is to say that any deficiency in the compliance with the MBE requirements or the MBE goals was deemed fatal. And while that approach initially was well intended and perhaps even justified, and I was probably one of the ones who argued for it, since I was an author of that original program, not just in Baltimore City, or in the state of Maryland, but around the country. I was probably one of the ones who argued in favor of that strict enforcement or zero tolerance. However, like most things, there needs to be an exception, particularly where the exception is mandated by common sense. Never should common sense be locked out of the process. And what do I mean? There were many cases, too many cases, where because of the low bidders' failure to achieve the stated goal by in relative terms a small amount of money, that bid was rejected in favor of a second or third low bidder at a cost well exceeding the low bid, and for having achieved a marginal amount, very slim amount of additional minority participation. And the amount of that additional participation was always marginal because no one ever offered a greater participation than the goal that was set forth in the contract. What am I saying? If the contract as issued by the city established a goal of 10%, I've never seen a bid come in offering more than whatever that goal was. Even though the language said that the intention of the program is to maximize the utilization of minority business, the fact of the matter is you only got the minimum requirement and not anything approaching maximum participation. Interestingly, as I said before last week, Baltimore City, as well as the state government and other government entities, upon a declaration that it had wrongfully denied the opportunity to get contracts to minority firms, rather than carving out an opportunity that only minority firms could be eligible to seek or to bid for, they rather shifted the responsibility for achieving minority participation to the prime contractors who had presumably benefited from the exclusion. Now, you might say, well, what's wrong with that? Well, a couple of things. Number one, it relegated minority participation solely to the subcontracting level. That means that there was no what's called privative contract between the government that was creating the preference programs and the parties and the contractors who were to benefit from that program. The result was, when there were disputes, as they inevitably and invariably would be, because there was a forced relationship between the prime contractor and the subcontractor, when there were disputes, the minority firms went running to the city and said, help. The city and the state government, federal government, all threw their hands up and said, we can't do very much to help you because we don't have a contract with you. And we cannot interfere with whatever contract you have with the prime contractor. So the minority firms, many of which who rushed to get certified, and then when problems, thinking that the government would protect them in circumstances such as I described, found out that there was little to no protection available. In fact, in many cases, the government wouldn't even talk to them. I mentioned before that originally at the state level, the primary agency for resolving disputes, the Maryland Board of Contract Appeals, up until a few years ago, by law, was not even permitted to get involved in the resolution of disputes over minority participation, showing again how little the government really cared, despite the lip service that we heard at all different levels. I remember, and I'll say this as an aside, I've probably been at this longer than what I should have, and that is to say, in this business of practicing law, I'm now going into 53, I think 54 years. But I remember there was a company called Perini Contractors that was bidding Perini was out of Boston, and they submitted a bid for a contract on the Baltimore subway system. And as evidence of their compliance with the MBE requirement, they were going to use the services of an electrical subcontractor, purportedly an electrical subcontractor called John Henry Electric Company. Well, as it turned out, John Henry was a warehouse worker for Perini, and they had gotten John Henry to agree to create this new company. John Henry was not even an electrician, by the way. He was a warehouse worker, a laborer. they got John Henry to agree to allow his name and likeness to be utilized as the owner, put forth as the owner of this minority electrical company, which and as such, to get certified as such, and then to receive ostensibly millions of dollars in minority participation as a subcontractor to Perini. I actually uncovered the scheme by going to Boston in a clandestine way and entering into Perini's office, and was able to retrieve some documentation to disclose or reveal what was really going on, and brought that information back to the city at the time. And again, this was many, many years ago. But I say this as evidence of the extent to which the community, the non-minority community, the lengths that it would go to provide ways of working around or avoiding doing what ostensibly was the purpose of the program, which was to utilize minority contractors to the quote maximum extent feasible. It never happened. It was never going to happen, and it still isn't happening. And the fact is that the biggest impediment, as I said last week, to opening up and creating the opportunity for minority companies or any small business to gain access to government contracting are the requirements that for being eligible to submit bids. The requirement to submit a bid bond, the requirement generally that the contract be awarded to the lowest bidder, which sounds good and sounds like you're protecting taxpayer money. But remember what the purpose, or consider, if you don't remember, what the real purpose of providing greater access to contracting opportunities is. The purpose of providing access is to increase competition. Competition. The more competition, the theory is that the lower price, the lower and the more efficient and more cost-effective pricing will come forward, and that will be available for contracting. But with respect to the real benefit of providing access is in employment, particularly if providing access to minority businesses. The fact of the matter is, and I don't think anybody would dispute it, that the minority firms that are owned by African Americans will, on a percentage basis, a proportionate basis of their workforce, a much higher percentage of their workforce is going to be African Americans than the workforce of a non-minority owned company. So that the purpose of providing the opportunity to the minority company to become a prime contractor is, in fact, to expand the employment opportunities for the minority community, not for the purpose of having a new owner who can buy more memberships at the Center Club, or buy a bigger Bentley or Rolls, or buy a bigger house. And that's not the purpose. Now, if during the course, now don't get me wrong, if in the course of your company being successful, you are rewarded as the manager or the owner of the company, that's all well and good. But the purpose of creating the preference was to provide employment opportunities, because notwithstanding the entrepreneurial spirit, if you will, and the government's goal to create more entrepreneurs, the fact of the matter is, at least in my opinion, the great majority of people are going to obtain income through wages. That is, as employees of other companies. And so if you want to increase the level of employment and substantial employment, and I have to stop and say that, because you've heard all the political hoorah about minimum wages and all that. Well, who really wants to work for minimum wage? I mean, just think about that. Would you when you decide to purchase a vehicle, do you want one that will obtain your minimal desires, that if you want to go 10 miles will probably get you 9, or do you want one to get no? no one really wants to work for minimum wage, because the minimum wage will not provide you with sufficient income to support your family. It's just that simple. People work for wages in sufficient amount to support their families. Minimum wage was never intended or designed to do that. It was a liberal way of a feel good way for politicians to say they've done something. This theory of doing something is better than doing nothing. Well, that's not necessarily true, at least not in my opinion. Doing the right thing is always better than doing nothing, but not just doing something, because something could be anything, and not the right thing. And why I say that, and let me also hasten to add that much of almost everything I say is going to be based upon my opinion. Now, somebody will say, opinions. Everybody's got an opinion. I would hope that over time you would agree that perhaps my opinion is more informed than some others, and therefore maybe having some degree of credibility over and above that of someone who's not had the experience and the history that I have in dealing with Baltimore City and other government agencies. In any event, so the city by charter is supposed to award contracts on the lowest responsive and responsible bidder, and that is a tremendous impediment to providing access to small and minority businesses, because you have to compete against the companies that have acquired capital assets and resources during the period when you were excluded. And so you've got the company who's been getting the business for 200 years and acquiring the assets for 200 years and acquiring the capital for 200 years, and who establishing the relationships with the banks and the surety companies for 200 years. Now you're having the bid against the newcomer, black, white, or green. It's a newcomer. Somebody who doesn't have the relationships, has not acquired the assets, doesn't have the capital, and doesn't have the relationships that the low bidder has acquired. And so you might expect that there's no real competition, because the playing field as such isn't level. Now, the problem with most people when they talk about a level playing field, they want to look at the situation as though it's a snapshot and not a moving picture. You can't look at the situation and say, okay, this is what exists today, and ignore how it got to be that way, or without establishing what it should look like when it has been changed to meet whatever your objectives may be. This has been a great problem all along. And in fact, it's been, and I'll talk in some later program about how that problem is in fact reflected in some of recent Supreme Court decisions dealing with the issue of race-based programs, both in higher education and really across the board. I'll talk about those things on another program at another level, now at another time. But the city also, the Board of Estimates, awards contracts on a basis other than by law, on a basis other than the lowest bid. The city has so-called emergency contracting authority and so-called select source contracting authority. Now, this is where it becomes interesting. On the agenda for next Tuesday is the proposed award on a selected source basis. Now, what does that mean? That means there was no competition. That means that somebody simply decided, I'm going to give them this work, okay? So the board is requested to approve a selected source contract with a company called Jay's Restaurant Group for the period of January 2025 through December of 2027, a 2-year contract worth $200,000 The supplier will provide food service, catering service for city employees assigned to work snow emergency shifts. And now here's the reason why this contract was not competitively bid, with meaning that there were no black companies or any other companies that had an opportunity to demonstrate that they could provide this catering service more efficiently and more cost effectively than Jay's. No one else had an opportunity to do that, because if this recommendation is followed, this will be on a selected source basis. And the reason for that is due to administrative issues. That's it. Due to administrative issues, a bid solicitation was not processed in a timely manner. Well, okay, if it wasn't processed in a timely manner, and if it's certainly an area where there could be tremendous competition, I represent at least two minority-owned companies that are three actually that are in the business of providing catering, and I know several others. But if it was just a matter of having enough time so that these companies would at least have an opportunity to submit bids, then defer it. No, defer it. I mean, or at a very minimum, if the service is needed immediately, make the emergency period or the select source period a month or 2 months, not 2 years. But because they didn't have enough time due to administrative, what does it say here? Due to administrative issues, because they didn't have enough time to competitively bid it, they're proposing to award a contract not for a period to necessary to have the time to do it competitively, but for 2 years. There's no such thing as a 2-year emergency, right? And at least in my opinion. Now, also, there's in addition to select source contracts, there are, which is a form of a sole source contract. Sole source generally means not without competition. Now, there can be and there are legitimate reasons for awarding a contract without competition. It could very well be that there is, if it's a situation where there's only one company. For all practical purposes, there's only one source for what you need, then what competition would that be? The company is not going to bid against itself. That would be a legitimate reason, at least at that point in time, for awarding on a sole source basis. But an emergency doesn't exist because the government officials or government employees didn't do their job on time. You know, you can't sit there for months not completing the work that you're supposed to do within a time frame that you're supposed to do it, and then declare an emergency and give the work away to who you wanted to have it, calling it an emergency. That is not an emergency. That is a failure on the part of the leadership to require the people that work for them to do their job and to do it timely. And who pays for those kinds of emergencies? Of course, the citizens, the taxpayers do. The lack of competition has the effect of allowing the awardee to that there's no test for whether the price is good, bad, or indifferent. There's no test for that. And so that's what competition does. It makes you sharpen your pencil, so theoretically at least. It makes you sharpen your pencil. It makes you offer the lowest price you can to get a reasonable return on your investment and offer the best product as desired at the price that's most affordable to the purchaser. That's what competition does. But when you award contracts on some basis other than that, you in fact undermine the very purpose of having competition in the first place. And we've had, examples all around throughout government, both locally and otherwise, of situations where contracts were awarded for reasons other than the offering the best service or the lowest price. We've had more than enough examples in Maryland and elsewhere in the country of pay to play contracts. What do I mean? you've got to separate the politics out of public contracting, because it's too enticing. It's too enticing to want to award a contract to companies who directly or indirectly contribute significantly, materially, to your getting your job, to your election campaign. It's too enticing. I told people that if you put the Hope Diamond on the conference table, such as where I am now, and you invite members of the clergy from all denominations, all Hindu, whatever, everybody, and you put them around the table, and that Hope Diamond right in the middle, turn the lights out and come back 10 minutes later, two things are going to be missing. One of those clergy and that Hope Diamond. Because the lure, the enticement, is too great for most, even well-intended people. The lure, the enticement is too great to account on them having the kind of integrity that will be able to resist that temptation. So you've got to avoid the situations where the temptation is present. You've got to. That means, in my opinion, you've got to have a system of awarding contracts, even if the final decision is reserved to elected officials, where the decision is at least you can have the confidence that the decision is made in a non-political, politically biased fashion, where the decision is without question made without regard to the extent to which the offeror or the bidder has or has not supported a particular candidate or provided contributions to a particular cause or any of those. Neither of those things is supposed to play a role in public contracting, because both undermine the confidence in the integrity of the system, both result in overpayment, if you will, by the citizens for work to be performed, and both are undermine the kind of, I'll use this term, transparency that is necessary. See, public confidence is perception is reality. Why we live in a time, and I'm about to close out now for the day. We live in a time where the public is told is being daily, have no confidence in your government unless I'm the one that's running it, and we know who that's coming from. But the problem is that the government cannot effectively perform its duty, even when it's trying to do. The government is people. That's all it is. It's just people in positions of authority. It doesn't mean they're better people than anybody else. It doesn't mean they're smarter people than anybody else. It doesn't mean they're more intelligent than anybody else. It doesn't mean they have more integrity than anybody else. All it means is they have the job and the authority that goes with the job. Right? That's all it really means. So that in order for those people to be able to do their work effectively, the people who don't have those jobs, you and me and the public, have to have confidence in their integrity, have to have confidence in their capacity to do and the desire to do the right thing. That our confidence has been shaken by those who attack the system just because they don't like the outcome. You see, there are times, and as a lawyer, I've had to face these times, particularly going before the Board of Estimates, when that a decision is made that I don't like. And I may, and my dislike for it and my disagreement, I'm sure has been evident in both my facial expression, my bodily expression, and sometimes in the appeals that have been filed. But not liking the decision, I should have enough respect for the process to have my disagreement heard in whatever way the law provides, but without attacking the system itself, because good because there are ways to change the system. The way to change the system is to change the people who manage it. That's the way to change the system. But to throw the baby out with the bathwater, so to speak, to undermine the system itself and not have a comparable system, a more effective system to replace it with, is leads to anarchy, leads to the kind of system, as my daughter, one of my youngest daughter once said, when I asked her to take a case for me at the Board of Estimates, she came back and said, and I told her she was going to lose. I said, but don't take it personal. It's nothing to do with you. I knew that the politics weren't right for us to win. She said, she came back and she said, Dad, you don't need law or facts when you go down to the Board of Estimates. All you need is a sweatsuit and a baseball bat, because that's from what I can tell, that has as much to do with the decisions that they make as anything else might have. And that's and the fact, whether that's true or not, the perception that it's possible, the perception that it's plausible, it makes it too true to be tolerated. Makes it too true to be tolerated. We have to have a system that the public has confidence in, but the confidence has to be for good reason. It can't just say, believe it because I say so. Believe it because you've observed the way we've operated it, because you've observed what we've tried to do, and even if you disagree, you've observed that we've done it the right way, even if you didn't achieve the same outcome that you would have achieved if you had the authority to make the decision. The way to challenge that is to put other people in the position of authority, not to destroy the system itself, at least not in my opinion. So we are at the end of another broadcast of the Board Watch. Please, I encourage you to tune in to the city channel if you're a city resident, channel 25. And if you're not a city resident or don't want to watch it, I think you can call in to listen through WebEx. And if you don't want to do either of those things, you can at some point watch the program, watch the board session on YouTube. And if you want insight, I think, hopefully, on why the board did what it did, what factors were considered that may or may not have been disclosed in the proceeding, tune in to the Board Watch. Thank you, and see you next Friday.